So there is this medicine in my hand. One day it's here, another day it's not. Why? There could be many reasons. The company could go insolvent, the government could ban it, and so on and so forth. But what about a pharma company trying to shut down another pharma company through legal recourses? In this video, let's talk about it. It could be competition, threat to a company, a new entrant in the market, or maybe a threat to public for sure. And now for whatever reasons, you want them down. But the question is how? For that, we will have to roll back to the year 1998. There were these two companies, Cadilla Healthcare and Cadilla Pharmaceuticals. Both of these companies were different companies, different entities, but with some arrangement, both of them were allowed to use the word Cadilla. Cadilla Healthcare used to sell this medicine called Pharmaceuticals for treating the disease of cerebral malaria, also called as falciparum. In 1996, they launched this product. And in 1998, Cadilla Healthcare got to know that Cadilla Pharmaceutical is also selling some drug known as Falcitab for the same disease, that is falciparum. Cadilla Healthcare sued Cadilla Pharmaceuticals on the ground of trademark infringement, passing off, etc. Both sides were going total offensive. Plaintiff, Cadilla Healthcare, whose brand is Falcigo, was claiming that the defendants, which is Cadilla Pharmaceuticals, whose brand is Falcitab, it's deceptively similar to Falcigo, and that too for the same disease. The defendant, that is Cadilla Pharmaceuticals, contended that this medicine Falcigo of the plaintiff is derived from the name of the disease itself, that is falciparum, and that's why you cannot claim rights over the said name. There were other contentions as well which was put forth. But fast forward, court held that in India, people get access to medicine very easily, whether there is prescription or not. People will get access to the medicine. There is public interest which is involved, and that's why court will not go super technical into seeing if the trademark are similar or not. There is some similarity, and then there is public interest which is involved, then court will grant injunction stopping the other side from either manufacturing, selling or marketing the said drugs. Similarly, there was this other case, Novartis AG versus Crest. Here the court held that if the disease is different, if the salt composition of that medicine is different, if the mode of administration is different, and if the brand looks same, the name looked same, the medicine looks same, then there will be dangerous consequence if ingested otherwise. In such situation, court will instantaneously grant injunction. Now these two cases are very important. Cadilla, where if there is little similarity and then there is public interest involved, there will be injunction. Then there is Novartis, where if the disease is different, salt composition is different, mode of administration is different, then there will be dangerous consequences, and hence injunction will be granted. In majority of pharma cases, the grounds of filing the suit is either trademark infringement, trade dress infringement, or copyright infringement. There are other grounds as well, but these three are the most common one. Now based on these grounds, cases are filed. For example, A files a suit for trademark infringement and passing off against B. Then A will make sure that B never knows that a case has been filed against B, because if B get to know that someone has filed a case against them, then there is a very huge possibility that B will start to dump off their product to make sure that they will say, hey, we're not selling it. Then here A will make sure that A will file an application under section 151 of CPC for exemption from issuing notice to B. Now a suit has been filed against B and B doesn't know about it. Then the second application is filed, that is an application for ad interim injunction, seeking that the other side is stopped right away from either manufacturing, selling or marketing the said medicine. If prima facie, on the face of it, court feels like yes, there is some similarity, there is trademark infringement or passing off, court will grant ad interim injunction, stopping right there the other side from either manufacturing, selling or marketing the said medicine. And the interesting part here is that the defendant doesn't know that an ad interim injunction has been passed by a court against them. But why? Because of this third application, the application for the appointment of LC. Court will appoint a local commissioner. The local commissioner with the police and lawyer will go and raid that place, the place where either the medicine is being manufactured or being marketed or both. The raid will be executed and the LC will write an on-spot proceeding report where he will write down every detail of what is being going on during the raid. If the competing medicine was found, if found, then how many medicines were found, what was their batch number, every detail. All these details will be very crucial during the trial which will happen in the court. And that's why the application was filed from exemption from issuing notice to the other side, because of this element of surprise. Because if they get to know that the LC will be approaching their premises, they will start off to dump off their product to the market and make sure that LC never finds out those products in their premises. Also, during the process of raid itself, the copy of the order of the court, and they are also being told that a case has been filed against them. Now here there are two possibilities. First, if the defendant is a very small company, in most cases they will get intimidated. They wouldn't want to pursue litigation and they would want to settle the matter. By the mean of settlement agreement, they will agree to never use this medicine or either their brand name or this trade dress or this copyright, and one day you will never find that product in the market. Now the second possibility is that if the defendant is a very big company, in most cases they would like to prolong the matter, they would like to continue the litigation, but at the end of it there could be a possibility that court will stop the other side from manufacturing, marketing and selling the said medicine, consequently making sure that that medicine is never found in the market again. And that's how one pharma company could shut the other pharma company through legal recourses.